Okay, guys, good morning. It is Thursday, October 26th, and we have an extremely small group today due to what I can only expect are technical issues. Apparently, a different link was put up somewhere, but regardless, we're recording this, so many of you will catch this on the recording as well. And it's an important subject. So first off, normal caveats. Anything that's said on today is, of course, going to be recorded and put out on public forums. Be aware of that, please. I have today a recurring guest of the channel, Richard Goldhar. And Richard runs one of the larger insolvency trustee operations here in Ontario. Richard's job over the course of maybe the past 5 or 10 years has been extraordinarily quiet. That is to say, he's kind of sat around and waited. And the reason his job has been quiet has been because people don't need insolvency trustees when times are good and when their main asset, being a house, is going up in value. Because even if you make bad financial decisions, even if you have no forward-thinking planning, the market will save you. Effectively, the values go up. You can refinance your way out of holes. You're good to go. But as the astute among you will know, and as perhaps is no longer something that is hidden from the public, market conditions have changed drastically in the past 2 years. And I think it's fair to say, and Richard will speak about this, that over the course of perhaps maybe the first year of higher interest rates, people were kind of holding their breath. But higher rates are deleterious to the real estate market, not only in the immediate sense, but in the long term. And it's when the long-term rates start kicking in that people suddenly throw up their hands and say, I can't do this anymore, particularly when the real estate market starts turning down or even illiquid, as is in the case in certain areas in Ontario. And it's to that end that they say, what can I do? As a lawyer, I'm having increasing conversations on those points every single day with people who say, I don't know what to do. I'm just going to leave this in God's hands, or alternatively, I'm going to default and see if they come after me, which in turn, people are starting to are being pursued by those people with whom they default. And at that time, the only thing a lawyer can do, the only thing a realtor can do, the only thing we can do is turn to someone who is able to deal with those people who have more debts than they have ability to pay. And that is a licensed insolvency trustee. I'm sorry, Richard, I'm giving a bit of a longer introduction than I normally do, but I really want to contextualize this to real estate before I turn it over to you. Licensed insolvency trustees have not the greatest rap out there in some regards amongst the general public. And to some degree, like lawyers, some are ambulance chasers, right? Like there's some lawyers who are just sitting there and they'll take any file and do whatever. And they'll sit there and they'll say, let me help you with your debt. And you see a bunch of smiling people and there you go. But more regularly, insolvency trustees play an invaluable role in the economic cycles of this province and help people when there is nowhere left to turn. Richard is here. I've known him for years. He's an esteemed bankruptcy trustee. He works with a lot of people, many of whom I've recommended. I've found him to have care and compassion for his clients. Richard is going to explain what happens when, firstly, you can't complete an agreement of purchase and sale, and the builder is just hovering like a sword of Damocles but hasn't yet sued you. He's going to tell you what happens when they do come after you. He's going to tell you the role of his job. And most importantly, from our perspective, he's going to inform you of what it is his profession actually does, because so many of us are not familiar with it, having gone through a wave of 20 years of real estate appreciation. You will have a trustee on your speed dial soon, similar to mortgage broker, similar to lawyer, because that's the economic circumstance we're entering into. And there's no one better to tell you about that than Richard. So Richard, without further ado, I'm going to turn it over to you. The people are filling in now. So please, this is a good time for you to start. And thank you for being here today.
Thank you. Thank you, Mark, for inviting me. I really appreciate it. And there's a long friendship between us, and I appreciate that as well. I'm going to start off with just displaying what a licensed insolvency trustee does, because many of you won't even know what we are. We are the only regulated profession in Canada to deal with debt. Do not be confused by people that tell you they're debt consultants or credit counseling or nonprofit. They're not licensed by the superintendent. The superintendent has licensed approximately 1,200 of us across Canada to serve all Canadians. And our job is to help those who have more debts than assets. And we help them by discharging their debt. And there's two main mechanisms that we would use to discharge debt. One would be a consumer proposal. That's the very advertised one of the consolidation of the debt, one payment, payable over 60 months, no future interest or penalties can be accrued from the date of signing. However, it does need the majority of creditors in the process based on dollar value to approve the proposal. Then the other alternative is bankruptcy. And I tell people all the time, bankruptcy is not bad. It's an alternative. And it really depends on an individual situation. As Mark said to you, having a trustee on speed dial, if you have some high level information on a client, we can do the quick and dirty analysis to tell you which way you should sort of be walking the client down before they come and see me. Because coming to see a trustee can be nerve-wracking. And I always say, come with your client. You've got the relationship. I'm just an expert in the field, like you'd have a mortgage broker and a lawyer. I'm just the expert in the field that will help your client and build you a long-term trusted relationship with this client in the future. Believe me, the economy will turn back again. House prices will come back roaring away, and trustees will go back to waiting again for another economic downturn. It is cyclical. Right now, as Mark discussed, there were a lot of individuals who purchased homes or condominiums on speculation. So that means they went to a trailer of a builder or a beautiful sales center somewhere, were fed and drank wine, and they bought what they thought was an incredible investment opportunity for themselves or their families. The market has turned before they were able to close, and now their lenders are unable to provide them the promised financing. And as it comes closer to closing, they're unable to fulfill their end of the contract to close the transaction with the builder. There's two options again for that. Some individuals, as Mark was alluding, are sitting back waiting for the builder to sue them. Every builder is still kind of figuring out their arsenal as to how they plan to deal with the situation. Because it's so new right now, they don't know if there's going to be a large number of defaults, a small number of defaults, how long the market's going to stay down for, how far the market will dip. So they're often just telling individuals, do your best to close, and they're not giving any further information. Others individuals who have come to see me already are saying, we don't care what the builder will do. We want to clear our name from this purchase agreement, take whatever financial measures we need to take, because we can no longer even afford to carry our other debts. Because we aren't, as Mark said, able to refinance our current home any further. So all the debt we're in, we need to get rid of it. And they're filing either bankruptcies or proposals, and that automatically is discharging the debt owing to the builder for the inability to close the transaction. I'm hoping that that gives you guys the broad stroke highlights, and I'd love to just answer questions for you.
I actually have a series of questions for you, Richard, but maybe I'll turn it over to anyone first and see what, if anyone has any specific questions for Richard.
Sandra here. I'm curious on the consumer proposal, how much on the dollar are you seeing on average that the creditors accept?
Perfect. So that's a great question, Sandra. And I'm going to tell you from an individual who has no assets. So they don't have houses with equity. They don't have any TFSAs. They don't have any investments in the stock market. No assets. We're seeing creditors accepting consumer proposals anywhere between 20 and 30 cents on the dollar, depending on who the creditor is. So right now, Royal Bank of Canada is being very difficult with approving their proposals. But I will covet this to tell you, there are only 3 voting houses in Canada that represent the majority of creditors in all proposals.
Richard, sorry, were you done answering that question? Can I ask? All right. I have a couple of questions for you. First of all, what's the role of a trustee in effectively threatening a position? In other words, I've never done this, but is there any point in basically approaching someone who is coming at you, and instead of filing, saying, we're going to be forced to file, here's the name of our client's trustee? Is that a negotiation tactic that may have legs with a potential creditor?
So again, I would say it's very dependent on the creditor. Many of the I would say aggressive creditors, so any of the particularly the banks, would respond and say, thank you, we'll await the documents from the trustee. Maybe a smaller creditor, maybe right now with a builder, because they're still getting used to the current situation and current market, they might go for it. But most of the time, they've outsmarted that situation. They've been around long enough to know, you want to go bankrupt, you want to do a proposal, then go ahead, because we'll get sworn statement of affairs from the trustee, which we could then review and execute based on the documentation we've received from your client prior to the application process.
In terms of someone who approaches your office, and I'm going to ask this question somewhat delicately. It's not born of my engineering. It's born of circumstance I see in the field, which is different. I often see people who come and say, I need a trustee, and they do so after magically no longer having any of the assets that they owned the year before. They had a house in their name. The house is no longer in their name. They had a cottage. No longer do they have a cottage. To what degree, what does a trustee do to make sure that someone isn't hiding assets so that you are able to ultimately say, this is the statement of affairs? And is there anything someone can do legally to actually protect themselves as against creditors who have not yet emerged? I know these are difficult questions.
Correct. So the first one, I'm going to say to you, the superintendent of bankruptcy provides us with a form that needs to be signed under oath by the debtor, the individual who owes the money. And one of the questions is, have you transferred, disposed, or sold of any assets in the past 5 years? And have you transferred or disposed of any assets in the last 12 months? And although they sound like the same question, they're actually very different, because the rules and regulations of a trustee in bankruptcy are, we can reverse a transaction within 12 months to a third party. Over 5 years, anybody that is related. So non-related it's 1 to 3 years, depending on what the situation is and how they got rid of it. And then related parties is 5 years. We can.
So a trustee is able, does that include for bona fide purchasers for value? Like, in other words, if someone goes ahead, if you dispose of a property for $1 million, that's properly $1 million, and you get $1 million in cash and then gamble it away,
then that's okay. If this is all about, if you do it on the down low, I'm gonna
got it. Okay, so it's
so
only
if you get true market value, you can sell your assets the day before bankruptcy. The question is going to be, what'd you do with the money?
right. Okay, and then you're going to pursue where the money goes. Got it. All right, I understand. Okay. And to Alex, I promise you, I'm not trying to take over your questions. I'm going to ask these questions of Richard right next. But just to my second question, is there a legal way of actually sheltering assets or in some way protecting yourself from a creditor that has not yet become a creditor? I mean, I guess a creditor is anyone that you owe money to, but
Correct.
a breach
So-
of contract doesn't mean you owe the money until such time as a judgment is there.
Right. So, I would always refer them to an expert in the field who does bankruptcy work as a lawyer, because they would be able to give the legal aspect. This comment I'm going to make is very practical with no legal diarization. I'm not a lawyer. Many people will use like housing trusts. Some people might use, if they're married and it's ambiguous on the ownership documents of the home, how much each percentage of the family member owned. They might sort of try to solidify that the spouse going bankrupt is only a 1% interest owner in the property and the spouse is a 99%. And it really depends on the lawyer, it depends on their expertise, and it depends on your situation, whether or not that argument would stand if it were to go to bankruptcy court. So
Understood.
it's not necessarily the bankruptcy action. We're truly guided by the act, the court, the act, the court, the regulatory body. Like, we don't make decisions fairly arbitrarily. And a big influence is the inspectors in a bankruptcy estate. And those inspectors could be any stakeholder in the process, but they're usually the most aggravated creditors.
Got it. Okay, that makes sense. All right, I'm going to turn my attention to Alex's question. She said, "Hi, what did the speaker mean about voting houses? Did I misunderstand?"
Perfect. I will clarify. So Bank of Montreal, RBC, CIBC, Scotiabank, Easy Financial, any of the big creditors, they no longer vote on the proposals in-house. They've subcontracted that work to individuals like FCT, Bankruptcy Highway, who have experts in the field that are looking at all the data from trustees across the country and helping to advise their clients on which way to vote in a very broad stroke on proposals and bankruptcy.
FCT's in that line of work. That's a brilliant line of work. I've never even heard of this. FCT is basically doing data analysis from you guys to determine if in fact they should accept proposals.
Correct.
Wow.
FCT is the largest, on an aside, FCT is the largest program provided to trustees. So it kind of makes sense. They really want to get in the data business, and they also extend on mortgage insurance. So.
Wow. Do you know Dave Cochran, who runs FCT's division for bankruptcy or for creditor?
No, I used to have a girl named Elizabeth Pate. She used to be the former president.
Yeah, no. This is different. This is their creditor pursue. Anyways, we'll talk about it after. He's an interesting guy. All right. Alex asked another question, which is, if your spouse is declaring bankruptcy, what about the other spouse? Does that affect? In other words, if you own a house 50-50 and one party declares bankruptcy, what happens?
So the remaining party outside of bankruptcy will be approached by the trustee if there's equity in the property to ask them to purchase the trustee's position in the property, because the trustee automatically now becomes your partner in this property. And it's either a yes or no. And if they say no, then you collaboratively work on a way to dispose of that asset. But in the general terms, if your spouse becomes bankrupt, it doesn't affect the non-bankrupt spouse unless there's any joint debt, right? If they have a credit card that's joint between the two of them, the non-bankrupt spouse would potentially be responsible for 100% of the outstanding debt, even though the bankrupt spouse went bankrupt.
And just for my own legal knowledge, in the event that someone is insolvent or makes a proposal, that doesn't mean that they cease to exist as a legal person for the purposes of law, by which I'm thinking of a very particular scenario in my office. If someone owns something as joint tenants with another spouse and that spouse goes bankrupt and dies, then the property as a whole transfers and there's no further claim on the property. Is that accurate?
That would be correct.
Interesting. Okay. All right, guys, what other questions do we have for the esteemed Richard Goldhar? We have 11 people on right now, so we could please, anyone who has questions, go ahead. I have more. I'm warning you. All right, I'm going to keep going. Richard, does anyone use a trustee in bankruptcy to negotiate as against individuals? I'm thinking specifically of the new build construct. Is there a point? I would think that if a letter that comes from a lawyer saying, we're just hands in the air, we're sorry, we can't do this, please let us go, is less useful than a letter from a trustee saying, my client is insolvent and simply cannot, or not insolvent, but my client cannot meet their obligations in this regard. And if you are planning on taking an action, we would ask that you contact us immediately. Like, that letter from you has a lot more weight than coming from me, because they know that they have all the legal rights in the world, and a lawyer can be easily just destroyed when I'm trying to defend someone as against the indefensible. Whereas what you're saying is, they've already come to me, and by the way, there's nothing here, so speak to me before you move. Is that not a better option for the purposes of someone who's looking to default?
So they absolutely could use our consulting arm. That's not a problem. But again, before we would issue a letter like that, unlike a lawyer, probably we would want them to go through the full application process so that we know whatever's being written is legitimately true.
Well, you're not, I'm suggesting to you that from a negotiation perspective, you wouldn't be making any attestation as to their assets or anything else. I'm saying to you, can trustees be used in the negotiation process?
Yes,
without
absolutely.
any sort of, they can.
Yeah.
Okay.
The trustee
Because-
is willing to use its letterhead. There's nothing that's stopping us in the act. It's just because we're constantly dealing with the same creditors, our reputation typically is that we would have some sort of documentation in house to show why they couldn't meet the obligation. Like, we wouldn't want to be sending a letter and then finding out.
Totally. But I'm suggesting not to your normal creditors, your banks or anyone else. I'm saying there are individual builders who are getting letters from lawyers saying my client can't complete. It is not a very strong letter that the lawyer is writing, because we're dead to rights. We just haven't abided by the contract. We haven't been able to come up with the money.
Right.
A better letter is one from the trustee, where the trustee is saying, this guy can't complete. Please communicate with us if you're going to come after us. Simply because what you're saying implicitly is they're already with a trustee.
Right. Yeah, no, I mean, we could use it. We could do it. There's not a problem. People do
Okay.
But I
it.
think,
People
but I
do
think
it,
any
right?
smart-
Like, at the right client, at the right time, it's not a problem.
but I think a smart builder, if they were talking to a trustee, they would automatically say, have you investigated, done your full due diligence on his financial situation? In other words, can you state that he can't?
A smart
That's
builder
what I'm
would.
trying to say to you. Like, the builders would typically know what we do because they're always dealing with us, even in good times.
Yeah.
Right.
Like, builders in general, no trustees, even in good times.
All right. So Alex has a question, and she's saying, with regards to timing, if a client can't pay a mortgage or can't close, is there a race between the creditor who is suing through the power of sale and the debtor running to put all debt into a consumer proposal?
No, because there wouldn't. I would say in that situation, you would just look at the debtor's situation on a holistic point of view and decide what makes most sense.
Yeah, if I may take a crack at answering that one, Alex. The reason that there isn't such a race as what you've described is because the vast majority of lenders who are lending have taken security that still has sufficient security in the home, meaning that they aren't engaged in the creditor process. They don't care. Even if someone is going through the creditor process, they're secured creditors vis-a-vis the house, and there should be, in almost all cases, sufficient equity in the house to pay off their position. So from their perspective, they're not in a race as against the generalized creditors. The security itself gives them a priority, which means that they're not sweating it. Does that make sense? Okay, Alex gets that. Fine. Okay. So, Richard, is there anything else you want to talk to us about? I know it's a bit of a shorter time today, but is there anything else? Anyone else has questions? Is there anything else you want to say?
No, I think, if people have questions on an individual circumstance, what I say about bankruptcy and proposals is it's so individualized. Feel free to reach out to me. Mark's got my contact. We operate across Canada, actually. We go right across Canada with the exception of Quebec. So,
and if someone wanted to investigate becoming a trustee, I mean, this is something where it's not even really something a lot of people think of, even though it's one of the more lucrative and interesting areas of professionalism and professional designation. Could they speak to you? Could they reach out?
Absolutely. It would be my pleasure to talk to anybody.
All right, terrific. So guys, thank you everyone. I'm sorry this was a small group. I have a feeling that was on me, but this will be posted and we'll have our normal rates of people who see this. Richard, I'm incredibly grateful. You've come out a couple of times, but more importantly, you've helped out actually quite a few people in the forum in the past. You've helped out a whole bunch of my clients in the past. Guys, as your clients end up shrugging their shoulders and say, I don't know what to do, remember, there's also a trustee you can speak to in addition to lawyers. And it's not a bad idea. Consultations are always usually just very complimentary and very quick. We can figure out who you need to be speaking to, a lawyer or a trustee, and then everyone can kind of proceed down those paths. Keep in mind that this is a definite option available to us, and it's one that we're going to see with more and more regularity as this market continues to turn down. And to be clear, even though brighter skies are always ahead, we have a rainstorm to get through first that's probably going to last for quite a bit more. We just have to work it out of the system. And while that rain is coming down, people like Richard are invaluable. So Richard, I can't thank you enough for being here today. Those people who attended, thank you very much. We will post this on the forum as we always do. Thank you, Richard.
Take care, everyone. Bye-bye.